Hi, I'm Paul Morrone, owner and wealth manager at Nexa Financial Group, and I'm here with Rob Heineman, a local trust and estate attorney who I have the pleasure of working with on a pretty regular basis these days. And one of the reasons, Rob, that I wanted to have you here was to just talk about estate planning in general for those that may be unfamiliar with it, because I know there's a lot of common misconceptions with it. Everybody thinks it's just a will. And, pick your brain on what you're seeing out there when someone new comes to you. What does a typical client say when they come through the door, and what kind of mistakes are they making? What are they thinking about that they shouldn't, and what should they be thinking about?
Sure. Well, first, obviously, thank you for having me, Paul. I appreciate the opportunity. So in terms of estate planning, you're right. There are a tremendous amount of misconceptions that are out there. And I would say very generally, estate planning, it involves planning for one's passing and for one's incapacity. And there are any number of documents that can be used for these scenarios. So the first document that people, I think, commonly reference would be a last will and testament. And your last will and testament is going to be a document that specifies what happens upon your passing. It allows for you to name your executors, those persons who will be handling your estate, and it also identifies the people to whom your assets will be passing. There's also documents known as trusts, revocable trusts, and irrevocable trusts. They're not suitable for every individual. It depends on an individual's facts and circumstances. Items such as wealth, family dynamic, assets that they own, if they own assets out of state, et cetera, et cetera. And then also a big part of the estate planning process that we deal with is preparing for incapacity. And largely speaking, there are two documents that we would consider when dealing with incapacity. There's something known as a durable power of attorney, and then there's also something known as the appointment of a healthcare representative. And these documents very generally, what they do is, in the event that you're incapacitated and not able to make decisions on your own, these documents identify somebody in advance who can make those financial or healthcare decisions for you. And if you don't have those, and unfortunately this happens quite a bit, we find ourselves in situations where individuals who were once had capacity, they have a certain amount of wealth, they have a normal life, and then perhaps, and you see this quite a bit, is early onset dementia, for example. They're not able to make healthcare or financial decisions for themselves. They don't have these documents in place, and sadly, the probate court needs to become involved in a proceeding known as a conservatorship.
So is it a safe assumption to say then a lot of the estate planning work that you do often involves not just what you have and where it goes, but the who is appointed and who the people are that are in charge of not just executing your financial or estate plans, but also caring for you in the event you can't yourself?
Yeah, so a big part of the process, and you never want to walk clients too quickly through the process where you say, we need to pick a person for purposes of filling in a blank space, right? You have all these different roles. It can be guardian for minor children, executors, trust protectors, trustees, agents under a power of attorney, and then also healthcare representatives. I think I just rattled off 5 or 6 different positions that people may need assistance with. You don't want to take those decisions too lightly. Some people may be a great healthcare representative because they understand what's involved in making healthcare decisions, but they also may have no financial sense, where maybe they're not the best person to serve as a trustee. Maybe there's something going on in their lives where they're just not going to be able to handle it. So I think when you're going through the process with clients, especially new clients, you really want to take the time to talk through each of these roles, what's required of each of these roles, and then some of the dynamics that go through the entire process.
Well, you answered my next question, and that would be, it definitely doesn't mean because one person fills role A that they need to fill roles B, C, and D. And often in many cases, the classic, the nurses in the family, that person typically bears the burden of being the healthcare representative, where, someone that's in finance or accounting may, inherit the role of durable power of attorney or disability trustee or something like that.
Correct, right? I think so. For example, you have a young couple that comes in and they need to name guardians and trustees for their minor children. Their children are 5 and 6 or very young, and they want to name somebody in their mid-70s, their parents, for example. And I say, well, look, I say, you're 75. Are they really able to take on that role as being a 5-year-old's new parent and serving as trustee? And I say maybe today they'd be able to do it, but 10 years from now, those children are 14 and 15 or 14, 16, whatever it is, and you also, at that time, you have an 85-year-old serving as guardian. Maybe it works, probably not. So I think it's important to really think through each of these positions.
One of the things that we talk about a lot in here, and obviously with your consultation or an attorney like yourself, is will versus trust. They're two obviously separate documents. I know they can be one and the same. We'll neglect the formalities of that for a second, but you're planning for almost two different things with each of them, and maybe it would be interesting to hear your take on when you would definitely recommend a trust, or in most cases, and or when a trust honestly just isn't necessary.
Sure. So that's a great question. So I would say probably once every 2 weeks, probably twice a month, clients come in insisting that they need a trust, and then they leave with opting to just have a last will and testament without a revocable trust. And what happens is, I think a lot of what you see out there in terms of why one would need a trust, it comes in the form of attorney advertising. And people take that advertising, they take it to heart, and because it does its job, it's an advertisement, and they insist that they need a trust. So when we come in and we sit with folks and we talk about the benefits of a revocable trust, for example, we would talk about privacy. If you fully fund your revocable trust during your lifetime, there are certain aspects of privacy that one may enjoy. There's also the thought of being able to avoid probate. But it's a bit of a misconception in Connecticut. In Connecticut, even if one passes away with no probate assets, there are still several filings that are required. And especially if somebody owns real estate in Connecticut, even if it's held in a revocable trust, there are still certain filings that need to be made with the probate court. So you have to be really, really careful when you're advising clients, because not every client necessarily needs the benefit of a revocable trust. You can use the revocable trust to avoid certain aspects of probate, but not all of them. I think the big one is, or the big ones that come up are estate taxes and then passing assets on to the next generation.
And sure, for the benefit of those that aren't aware how much estate taxing really comes into play, the thresholds right now, at least under the current laws, they're so high that very few people are actually subject to estate tax.
That's
and
correct.
The reason being is the exemption is somewhere near $16 million per person. So with proper planning, you could essentially pass almost $32 million tax-free to the next generation with just what I would call basic trust planning.
Correct. The exemptions are scheduled to come down in January of 2026. What ultimately happens there, we don't know. But the big thing with the exemptions being so high, and they have been high for a considerable amount of time, I think the big thing that I see is passing assets on to the next generation. So for example, somebody comes in, a married couple comes in, and they have 3 children, and let's say hypothetically the married couple has $3 million, $3 million. If both parents or both the clients were to pass, each of their children would inherit, call it $1 million. And the question then becomes, are the children ready to inherit $1 million each? Or should their assets be suspended in a trust for their benefit? The children would have something known as a beneficial interest in the trust, but they don't own those assets the way that we think of ownership. So for example, God forbid one of the children were to be divorced or sued, assets that would be held in a trust for their benefit, if properly structured, would not be includable as theirs for those purposes. You also have situations with children, whether it's substance abuse, gambling, litigation, the whole host of the things that we worry about as parents, where certain people are just not meant to inherit $1 million.
Absolutely.
And it's a very easy planning technique. The hard part I find is getting clients to the point where they're comfortable. We work with them on selecting a trustee, making sure that the person that they're selecting as trustee understands what it means to serve as trustee. And in doing so, when the time comes, if those children would otherwise be receiving $1 million outright and free of trust, their assets are suspended in trust. That's not to suggest that they don't have access to the funds. They do have access to the funds, but it's only through a trustee. And that dynamic there, that relationship, that's what keeps those assets protected.
Sure. And passing assets in trust and funding that trust while alive is really one of the biggest areas where our two worlds interplay, right? The financial planning aspect and the estate planning aspect, of course, in the big picture stuff come together. But when we talk about funding the trust, I'm sure you've seen it a host of times, and I know I certainly see it, especially when we take on a new client. They think they have this really robust estate plan, and it's great. They have documents that meet their goals and wishes and whatever it may be, but their trusts aren't funded. And if one of the reasons they wanted a trust was to have their assets bypass probate, well, we just kind of negated that, because now all those assets that they own either jointly with their spouse or outright solely, those still have to go through probate to ultimately get into the trust. And when I talk about big mistakes I see or things that fall through the cracks, it's a lack of communication between the two professionals that are really championing this effort. And look, no one's going to stop their client from going to the bank and opening up a new CD and forgetting to register it, right? I mean, as diligent and as vigilant as we want to be, that's still going to happen. Mm-hmm. Maybe you could speak to that, where issues you've seen as a result of someone that thought they had an estate, or the spouse thought, and it didn't go as planned when it came time to administer.
Sure, and it happens all the time, right? So it is important, and you and I have worked on this quite a bit. Whenever we've worked together on an estate planning client and that client signs their documents, then we would debrief and discuss their asset allocations and making sure that, for example, if there's a life insurance policy that is required to, or we would want it to be paid to the trust and not necessarily to the estate, so we're avoiding certain elements of probate, we're providing a certain amount of liquidity upon one's passing. All it really takes is updating the beneficiary designations on an account and confirming that that's been done. It seems relatively easy, but it does get missed quite a bit. Same thing with brokerage accounts, retirement accounts, those beneficiary designations, those forms that we all get when we open an account, they may seem innocuous, but we know that they're actually really important, right? Those designations control, and they actually trump the provisions of a will or trust. And that's why it's essential that you make sure that the estate planning documents that are being prepared, you make sure that they coordinate very well with any beneficiary designations.
Absolutely. And that's one of the things we often spend a lot of time on is beneficiary designation, taking an inventory and talking to the clients about the various different outcomes that you're going to get from using a beneficiary designation versus an instrument like a will, and potentially how maybe the trust should be the beneficiary, or in some cases shouldn't. And there may be assets, especially under the tax rules that we're operating under the Tax Cuts and Jobs Act or the Secure Act and everything, where all of a sudden maybe using a trust for small IRAs doesn't make sense because of the record-keeping requirements, the cumbersome drafting that requirements that are involved.
Income tax filing requirements.
Income tax filing,
right. So the way that I think about this is very practically. I have been practicing since 2007, but I would venture to say that 30 years ago, 401ks were probably a relatively new concept, a relatively new product. And I could be mistaken, but
they certainly didn't have the balances that they do today, at least
they don't
broadly.
have the balances. And now, you see phase outs of pensions, and now you see, everyone's walking into their estate planning consultations with a 401k. The 401ks are they're heavily regulated. The legislation is often changing. And a lot of that legislation is involving taxes, income taxes. So you do need to give it a certain amount of attention. And there are traps that you can certainly walk yourself into.
I would say more traps than not when it comes to estate planning with IRAs. And it's not just for the person that owns the IRA, the employee as they would be called during lifetime, the person that funded it, created it, and probably spent some of it. But also, with what's now called the 10-year rule for the beneficiaries, it becomes almost like a ticking time bomb for tax purposes, because you have these big tax deferred balances that in most cases, and there are exceptions to that, but in most cases need to be distributed to the beneficiary within 10 years.
Sure. So you have to take a look at, not only when you're meeting with somebody for an estate plan consult, not just how old they are, but you also have to give some consideration to their children and where those children are, because those children who will ultimately be receiving those accounts, they have 10 years or so after the passing to take those distributions or receive those distributions. Those distributions, as you know, they've built up deferred capital or built up deferred compensation. there's some really serious income tax consequences. So we're mindful of not just the, who's going to get it, but also at the time that they receive it, what's going to be happening with their own personal income situation. How are these assets best left? And it is something, there's a lot of thought that goes behind it.
Sure. And when we're talking about this with clients from the financial planning standpoint, a lot of times we're asking about where their kids are in life. And, you have, let's assume a normal, healthy life expectancy. Maybe a parent passes away, their 70s, 80s, maybe even early 90s. A child could be inheriting this really large tax deferred asset, possibly 7 figures or more, in their peak earning years. And
Right.
if their children are half as successful as they are, they're probably already being taxed in the, 24, 32, 35% rates. So these really big things that need to be distributed over a relatively short amount of time can really pose these planning albatrosses. And, to some degree we can plan for it, but sometimes we just got to deal with it. But again, back to careful trust drafting, if that's the appropriate way to do it. We can work with an attorney like yourself to give the client and the child maybe a little more flexibility than just saying, here, it's yours at my death. Maybe if we pass it a little more intentionally, we can get you a little more flexibility with how you're going to pay your tax burden.
Of course, and I think the important thing to keep in mind with all of this is that clients come in different shapes and sizes, right? And even clients that fit a similar profile, their situations, if you really got into it, they're all very different. Again, it's not a process that is to be rushed. It really requires not just one conversation. It's, really getting into it with clients, understanding their values, what they want to have happen, giving consideration to how old they are, their current health, their children's needs, where they think that their children are headed. And then one of the things that I do at my office is once we sign our estate plan documents, it doesn't mean that we necessarily go away. We will calendar a reminder where we need to reach out with to this person in a year, or this person is 5 years, whatever it is at that time. We can reach out, schedule a follow-up appointment, and that way clients are not left being in a lurch where they say, well, I met with my estate planning attorney 10 years ago, and that does happen quite a bit,
all
frankly.
the time, yeah.
And in doing so, working with folks like yourself, we can say, hey, Paul, it's time to meet with Mr. and Mrs. Smith again. It was 3 years since we signed their documents. Has anything changed? Do you know anything else that may be going on? And in doing so, you're mitigating any risk of the unknown.
Yeah, and one of the things that I think clients really appreciate about how we handle their situations is being proactive, not just on the investment or tax front, but things like estate planning, where if a client comes in and, we see our clients very regularly. We have to for a lot of reasons, but we want to as well. And oftentimes they'll share something that is a red flag to me, that is, hey, we got to call Rob, because if you haven't brought this up to him, it's a really important aspect of that's impacting your estate plan, and we may need to make some changes as a result. Now, that's not always the case, but it's always nice to vet it with someone that actually, knows things at a little bit deeper level than we do. But hopefully we're the first line of defense to at least pick up on potential issues as they come up.
Sure, I think you absolutely have to do it. These things are not in isolated separate boxes, right? You have, I'm often working with financial advisors, insurance professionals, accountants, because a lot of the issues that come up in these meetings, they're not just related to their estate planning. It's their overall financial picture. It's their insurance needs that come into play. The big one I see all the time is tax work, finding a suitable CPA. They're not sure of what's happening. Their CPA is retiring. They haven't been able to connect with somebody new. So, it's important that we're all working together, a team approach. Yes, there is obviously a cost to working with professionals, but what I would say is, at the end of the day, clients that work with their professionals and they work as a team, they will end up in a better spot than they would have otherwise. When you keep your professionals in isolation and separate from each other, or you just don't work with professionals at all, well, that's when you see the situations play out where somebody's passed, and this happens all the time. Retirement accounts not naming a beneficiary, $500,000 being paid to an estate, you're paying a very high rate of income tax right off the bat. It could have easily been avoided if you had working with a financial advisor and simply naming a designated beneficiary.
Absolutely, and part of our job when it comes to planning for that ultimate death event is back to my point about, where your kids are. A lot of times parents are willing to, make gifts to their kids in these more subtle ways. It may not be an outright gift of cash, but when we talk about investing in taxes for their kids, they may be willing to pay taxes on some of their IRA assets while they're alive, because maybe their rates are lower now that they're retired, their income situation is a little bit different. So contrary to, the old adage of defer your income and accelerate your expenses, we're trying to flip the script on that a little bit and be proactive with our tax planning so that, these, in some cases, well-off kids aren't stuck with huge tax-deferred balances, and we're doing Roth conversions or just pulling money out of retirement accounts. Again, using tax planning as a tool on an annual basis to make someone's balance sheet a little more tax efficient, not just for their own benefit, for the benefit of future generations.
Of course, and like I said a few moments ago, I think clients come in all different shapes and sizes, right? If a cursory review of a client's profile, mom and dad each have a couple $1 million, and there's an IRA, life insurance, a house. But I think what's important is you really have to get into the weeds a little bit and say, all right, tell me about your children. Tell me about where they're going. Are they married? Are they planning to marry? Do you like their child's spouse? Mm-hmm. And when you start asking these questions, you start picking up on these nuances. And these are the nuances that make a difference, right? Those are the things where you're issue spotting and you're able to add more value to clients' overall tax picture or investment strategy or whatever it is.
Yeah, and I've gotten so bold as I mature in my career where I just bluntly ask the question, like, what do you think of your son-in-law or your daughter-in-law? And sometimes people are a little taken aback, but I think it's a really good conversation starter because you get that knee-jerk, like, what's their face look like in that 3 seconds? And then you probably get a more honest answer than if you dance around it. So, and we've gotten some really good feedback as a result.
Well, no, it certainly makes a difference. Divorce is a real thing, and it happens, and it is something that's very relevant to the estate planning process. And there are certain things that you can do in advance of a child's failed marriage where you can add a lot of value to a client's situation.
As part of any sound financial plan, there's the investment plan, the tax plan, the asset allocation, investment, etc. But one of the things that we really pride ourselves on is making sure people's estate plans are in order. So if someone doesn't have one, especially, one of the first things that we're talking about in our first data gathering meeting is, do you have an attorney? And if not, we need to hook you up with one because we're not going to let this process go and you not get an estate plan out of it, because we know all the pitfalls that can occur if you don't have one, right? An estate administration intestate in Connecticut, assets could end up in unintended hands, and that's one of the outcomes we are avidly trying to avoid. So we're working really hard to do so. And I think when we're making that introduction to someone like yourself, our goal is to really find a good match for the client and who someone's going to match with personality-wise, who has the technical expertise to be able to administer an estate plan and draft it technically. If someone's not a good fit for someone like you, maybe they need a Title 19 attorney, which is a totally different form of elder law. So I think that's one of the things that we take a lot of time to make sure we're making those right introductions and that we think is going to serve our client best. So if someone was to walk into your office having never completed an estate plan before, they're totally green with this, they have no idea what it is, what would be some of the really key points that you try to drive home so they left your office feeling informed and ready to take action?
Well, look, here's the thing, right? I am certainly not a salesperson, and I am not going to offer somebody a sales pitch on why they absolutely must need to get something done right away. But what I can do is speak to them very concisely about here's what can happen if you don't have an estate plan. And here's just a couple of things, right? One, it's more likely that, I think, in my opinion, that your family there will be some form of infighting because there will be no direction left to who's serving as executor and where your assets ultimately should land. The other thing is the process inevitably becomes more expensive. Another thing that comes up is the fact that there's no direction in a will to specify where your assets go. With that, you're left with the default provisions under the Connecticut General Statutes of how your assets are to be distributed. That's not always the intended way that you would want your assets to pass. And I can get into more specifics with clients about, hey, if you owned a business and you don't have an estate plan, this is what can happen. Life insurance that doesn't name a designated beneficiary. You maybe thought you were intending to provide for your family, but you're not. And I usually, you go through a couple of those facts and circumstances, and you're able to get folks to realize, hey, this is actually somewhat important, a little bit of an exercise, it is a process to get have an estate plan completed, you can alleviate and mitigate most of those concerns.
Absolutely. And one thing we always try to remind people of is that just because you did something today doesn't mean you can't change it tomorrow.
Of course.
And in many cases, having something that meets your needs today is better than having nothing and hoping for the best. And that's, again, one of the things I find most important.
And that's why you can't just put your clients on a shelf and forget about them. It's important to call it 3 to 5 years, check in with your clients. Hey, did anything change? Any significant appreciation in assets? The person that you named as executor, are they still able to serve? And most of the time they're going to say, yeah, everything's great. I'll talk to you again in 5 years. But realistically, you do that 10 times, somebody's going to say, hey, thank you. You just jarred my memory. I need to come back and see you. And when you do that, you end up, it makes life a lot better when something does happen to a client and you have an updated estate plan in hand.
Awesome. Rob, thank you very much for the time.
All pleasure.
It was a
Thank you
pleasure
for
as
having
always.
me.